Welcome back to Making the Case. We've rounded up some of tonight's top legal stories, and to help break it all down is veteran prosecutor and legal contributor Paul Henderson and civil rights attorney Maria Bánjọ. Glad to have you both on. We've got a lot of ground to cover, so let's get right to it. Starting with new developments in the case against R. Kelly. With just 2 weeks before jury selection, federal prosecutors in New York have asked a judge to add additional allegations, including claims that Kelly sexually abused a boy. Paul, walk us through these new allegations, please.
Sure. So there's a couple of new charges that include bribery, trying to secure or having false identification, and also a new sexual misconduct action against a boy, some engagement that was enhancing some of the other charges. And so all of these are three new charges. It's a 55-page document. But the thing to take away from this is that these new charges are coming just weeks before the trial is to begin. And that raises a couple of issues for two big reasons. One, because his entire legal team has flipped over, and the remaining lawyers that are defending R. Kelly are newer lawyers. And then two, whether or not giving them enough notice to prepare and present the trial on the scheduled date is always an issue. So those are the things that I'm paying attention to. And quite frankly, if you really want to know what's going to happen to R. Kelly, we should be paying close attention to the rulings from the judge, the in limine motions that are going to determine what's going to be admitted in the trial. And because of these new charges, what new charges will be allowed to move forward for the trial. But, it just seems like things are mounting up against R. Kelly, and it seems rightfully so based on the evidence that we've all seen over the past few weeks and years. And quite frankly, this trial can't come fast enough for me. I'm ready for this to be resolved and for R. Kelly to sit down for a very long time.
Maria, prosecutors are not bringing any new charges against Kelly. Rather, they're being added to allege a pattern of conduct. Do you think the judge will allow the prosecutors to introduce this sort of evidence?
You know, it really depends, because sometimes when you bring overwhelming evidence of a pattern, it then becomes too prejudicial, thereby eliminating the defendant's right to a fair trial. And so I think the judge at the end of the day is going to have to balance that out, whether they should admit this evidence and what impact, if any, is it going to be on the prejudicial impact for the defense.
Paul, so Maria brought up the prejudicial impact. Now, this sort of evidence is often admitted in sexual assault cases and always controversial. We know it was one of the grounds on appeal in the Cosby case, although the court didn't even decide that issue. And it's also the subject of Harvey Weinstein's appeal. Do you think this is a wise strategy on the part of the prosecution?
I think it is, because I think the three new charges are independent and distinct from many of the other charges. The information about the bribery attempts for a court clerk, that's fairly new, and the evidence, at least from what it seems in the allegation, is pretty clear and straightforward. Also, the information about having false ID alluding to R. Kelly's relationship with Aaliyah in the past, that's new information that's distinct from the other racketeering charges that have been made for it. And certainly having a new victim, and a male victim this time, with inappropriate behavior with two, at least, younger male victims, is somewhat new too. And at some point you have to balance against the arguments that could be made for modus operandi against actual truth and actual offenses that took place. And it's somewhat a sophisticated argument that needs to be made in defense of R. Kelly that, quite frankly, I'm not sure, given his new legal defense team, whether or not they're going to be able to address it adequately, moving this close in time to the actual trial. But I think that the charges are valid, and I think they will put a bow on the prosecution's attempt to move this forward. And just to keep this in mind in context, we're talking about a federal case, so we're talking about a lot of time being stacked up against R. Kelly, and a lot of time that he's facing and likely to serve if he gets convicted.
All right, guys, turning now to the news out of Washington State, where several new police reform laws took effect this past Sunday. The laws include a ban on chokeholds and neck restraints. They also restrict the use of tear gas and ban no-knock warrants. Officers are also required to intervene if they witness a fellow officer using excessive force and render first aid if someone needs it. Washington's Governor Jay Inslee said the goal of the legislation is to reduce the use of deadly force. Now, Paul, does this go far enough to make substantive changes?
Let me start off with a resounding no, it does not. It's a step, and it's an important step. And I would like to point out that one of the things that I think is so important about this step is we're still talking about reforms that are so important at the state level because we don't have national reform taking place yet. The George Floyd bill is still being stalled and has not been enacted, so it's leaving a vacuum for states to take this action. I will say, for me personally, I'm offended by the arguments that's coming out of the state from law enforcement agencies saying that they want to stall, delay, or end these reforms because there's confusion about how to move forward. Because you know what I'm not confused about? I'm not confused about the race disparities in arrest. I'm not confused about the race disparities in the use of force, and I'm not confused about race disparities and injuries that are coming from having these bad policies. Enact them now, enact them yesterday, and be a model for other states to follow. There's no need to guess as to how we need to move forward to address these reforms and accountability. We can look to states like California. You can talk to police chiefs like Bill Scott to talk about some of these reforms. And here's just the answer. I know you didn't ask this question, but I want to say what the answer is because I think it's important when we're talking about these reforms. It's one, to establish policies and laws that reflect best practices. Two, to connect those rules to the trainings that take place with law enforcement. And then three, enforce those rules with both accountability and discipline. That's the answer. That's what we need to do. There's no confusion there. That's just the answer of how we need to move forward with this accountability reform. And I'd like to see it take place more broadly at a local, state, and at a national level.
All right, guys, we have more legal stories in the roundup when we get back from this quick break, but we've got more when Making the Case returns. Welcome back. Still with me are my legal experts, veteran prosecutor and legal contributor Paul Henderson and civil rights attorney Maria Bánjọ. Maria, I wanted to get your take on the last issue that we talked about before the break. There's been a lot of discussion lately about the limits of legislation to affect real change. It doesn't matter if you have laws in place if prosecutors never bring charges. Do you think police reform legislation is meaningful, or do we need more radical change, like divesting from police departments and investing in social services?
I think absolutely the police reforms that are currently happening is definitely a step in the right direction, but I definitely believe that we need to make sure we are investing in our communities. Because what we know that when we invest in our communities, when we prevent people from coming in to the system, that is better for everyone all around. And at the end of the day, the various police reforms that are going on across the nation is going to increase safety for the officers, is going to increase safety for the community. And what we do know is that when the police and the community are working together and there is trust there is greater safety for all parties involved. And at the end of the day, accountability should not be something that is partisan, should not be something that's up for discussion.
The Ninth Circuit now, the Ninth Circuit solicitor in Charleston, South Carolina, has said that there will not be any charges against the 2 Charleston County jail deputies involved in the death of Jamal Sutherland. He was a 31-year-old black man who suffered from a mental illness and died as Charleston County detention deputies attempted to forcibly remove him from his jail cell back in January. Now, officers repeatedly tased Sutherland and used pepper spray, eventually pulling him from his cell. In a press conference held earlier today, Jamal's mother spoke about the decision.
Why is he dead? And the only person that's going to answer that for me is God.
Paul, your reaction to the news that neither of the officers will face charges?
I'm extremely disappointed, but it also, to me, stands as part of the reason why we can no longer continue to wait for these reforms. It's the rules themselves that have not been addressed in decades that open the door to the subjective and intransigent decisions that create the race disparities for communities of color when encountering law enforcement. And so I'm really frustrated. We've talked about some of this before, about the 3 separate tracks of accountability that are criminal, civil, and administrative. And in this case in particular, we've seen the civil settlement, the $10 million settlement for his estate, and yet he's still dead. We have not seen new rules come into place in this jurisdiction that are going to speak to broader reforms and accountability that would have prevented that. And so that, to me, is what today's ruling and today's decisions about the criminal charges mean, that we need to shine the light on that we need to move forward in all areas in order to make it happen. The criminal limitations in this case, which again reflects the subjective prosecution decision that was made. The prosecution said that they were limited by the mens rea, or the intent, that there couldn't even be a manslaughter because there was no reckless disregard in this case. But, you know, to me, that's a subjective interpretation for prosecution. What about the reckless indifference here? What about the intent that's shown from the behavior that we saw on the video in and of itself to prove the intent? And again, I know and understand, no one knows that better than I do as a former prosecutor and a veteran prosecutor, that those are decisions that prosecutors make. But in this case, we are left with a death, and we are not left with a pathway to reform to make sure that deaths like this don't occur in the future. That's the problem.
Well, Maria, the solicitor even admitted that error after error by officers led to Sutherland's death, including clear negligence by deputies. However, she says there was no criminal intent, and so she's unable to charge them. Your thoughts?
So, although we may believe that the police reform is not moving forward enough, at the end of the day, all these laws are based on systemic racism, and that is the starting point. Until we change the actual laws on the books, make sure we give prosecutors the tools that they need to now hold officers as well as deputies accountable, we're going to have the same situation. It's my understanding that this young man was charged with a misdemeanor crime. That should not end with him losing his life. It's also my understanding that his family sought out help, and in addition, he was arrested at a mental health hospital. I mean, this is quite disturbing. Everyone should be appalled, and I believe the laws on the books must be changed so that prosecutors are able and they're equipped to have accountability.
All right, let's turn quickly to some national legal news. Earlier today, it was announced that President Biden was nominating Rachel Rollins to be the first black woman to serve as U.S. Attorney for Massachusetts. Maria, Rachel Rollins is not only a black woman, she's one of the country's most progressive prosecutors. How significant is this move, given that Biden has been very much focused on law and order to date?
It is tremendously significant. You know, despite, again, what we may feel about the way progress and change is happening, this is where it begins. When you don't have people who are making these very important life and death decisions reflect the community in which they are prosecuting, with the community in which they're serving, you are always going to have situations where you're not going to be able to really effectuate justice. Justice is not necessarily black and white. Justice has to take into account life experiences. And again, the more diverse those experiences are from prosecutors, the better off the community is. And this is a great step in the right direction.
Paul, I'll give you the last word.
Okay, here's what I'm excited about, that once again, a black woman is coming in to save the day. And at a national level, we're having specific and intentional conversations about choosing that black woman to address both reforms and race disparities. I'm excited that Biden is saying those words and talking about that and reflecting an intentionality that I'm excited about. And here's what I expect from Rachel Rollins: to follow up on the things that she has committed to, which are life without the possibility of parole and how that gets charged in a race-disparate way. And then I'm also hoping that she addresses specifically, as the U.S. attorney, the drug disparities and charges and sentencing. And having her at this national level, elevating her reform agenda at a national level, is always a good sign. So I'm here and I'm clapping for it. I'm excited about her voice contributing to the conversations that we're having at a national level. And I'm still a little curious, though, about who's going to fill her spot at a state and local level when she leaves, and if the work that she began is going to be continued in the same direction that she started. I hope that that's the case.
All right, veteran prosecutor and legal contributor Paul Henderson and civil rights attorney Maria Bánjọ, thank you guys for your time tonight. Coming up next, the investigation of a young black woman who died after repeatedly pleading for help in jail. Her family's attorney joins us to discuss the case.